everyone, this is installment number 2 of our video series Widlene versus Hussen. This one's on the concept of procedural fairness. This is extremely important and extremely pivotal to this case. So I want to explain this concept that the government outlines of procedural fairness and explain how we've not received any procedural fairness whatsoever in this process. So let me read, and we'll get it on your screen, but let me read to you from IRCC's website under procedural fairness. It says, decision makers are required to follow the rules of procedural fairness throughout the decision-making process. Procedural fairness requires that applicants, number 1, be provided with a fair and unbiased assessment of their application. Number 2, be informed of the decision maker's concerns. And number 3, have a meaningful opportunity to provide a response to the concerns about their application. Now, this is actually a great concept because the layman's version of this is very simple. You apply for a visa officer reviews your application. If they see reasons that you can't be accepted into Canada, reasons to reject your application, under this rule, they're required to give you a letter, procedural fairness letter, stating here's the reasons why we feel that you may not be admitted to Canada. And then you're given, theoretically, 30 days to respond and address those concerns. So it could be something very clerical. It could be that the visa officer, or maybe even in the linguistics of the application, something looked a certain way, it looked fishy, it really wasn't, and then the visa officer says, hey, this looks like something's not right, and you go, oh, well, that's because it was translated improperly, or that's because this, or whatever. You give an explanation, and if the explanation is legit, then it scratches the concern out of the head of the visa officer, and they move on. So when it comes to a judicial review, which is the process we're in now, normally, if you can prove that the rules of procedural fairness were violated, it's an automatic granting of judicial review. So in order to prove that, you got to prove either that you were not given all of the reasons that your application might be denied in your procedural fairness letter, or that your response to procedural fairness was completely ignored. One of those two things. So let me read you a procedural fairness letter that we received on Widlene's file back in May of 2018. Blah, blah, blah. I won't get into the whole thing. I'll just read the 3 points. These are the concerns. Specifically, I have concerns that the guardianship document that you've provided in support of your application may be fraudulent. We've attempted to verify the document and note the following anomalies. Number 1, the notary who authored the document passed away in 2014. His replacement could not confirm whether or not the document had been properly registered in Haiti. Number 2, the document's in English, which is unusual for Haiti. Grandmother would be giving approval on a document in a language she does not understand. Normal protocol is to provide the document in the original language along with the translation. This was not done. Number 3, grandmother is illiterate. Normal protocol in such cases in Haiti is for a person who cannot write to place her fingerprint in the signature area. This was not done. We cannot confirm that she actually signed the document in the absence of her fingerprint. So this might sound redundant because I've addressed this in previous videos, but I'm going to do this really quickly. Number 1, the notary died. There's not much that we can do about that. It doesn't change the authenticity of the document, but we have addressed it, and I'm going to show you how we did. Number 2, documents in English. Well, you'll see on your screen, according to IRCC's website, it actually says there's a question under the FAQs, and it says, what language should my supporting documents be in? Unless we tell you otherwise, all supporting documents must be in English or French. And in fact, we submitted a document in Spanish prior to this one, and they came back to us and rejected it. And they said, translate it. And they sent us a translator for $300 to translate it, and they didn't even want the original Spanish, they just wanted the translated version. So we thought we'd cut that out and just give them the translated version. But they took exception to that. And then the third one, of course, grandmother illiterate, normal protocol in Haiti for a person who can't write, put their fingerprint in the signature area. Let me read you Canada's Signature Act, which I don't know why he said protocol in Haiti, because it's got nothing to do with Haitian law. Usually a signature is simple, someone's name handwritten in a stylized fashion. However, this is not really necessary. All that needs to be there is some mark that represents you. It can be, as many signatures end up, a series of squiggles, a picture, or historically, even an X for the person who couldn't read or write. That is mirrored in Haiti's Signature Act as well as Dominican Republic's. I read from the Canadian Signature Act. So this person, the visa officer, is just wrong, and that's fine. That's why they submit this to us, these 3 issues, and we've got 30 days to give them a response. So what we did, we gave them a response, a giant document including affidavits sworn and signed by Widlene's grandmother, who issued the guardianship document that's in question, Widlene's sister, we just added another person, and by Widlene herself. So we addressed all these 3 because the new affidavit addressed that from the grandmother, said that yes, when we signed the guardianship agreement, it was our intent to assign guardianship to the Earls. So that removes the idea that it might be fraudulent. We did it in Creole, and then it was translated to English, which was submitted to you. That addresses that. And our intent was always to sign off on this adoption. So that was all done in a new affidavit within the 30-day period of the procedural fairness letter. The sister said the same thing. There was no biological father ever present, and all these things. To address the notary that had passed away, we had this signed and notarized in the Canadian consulate office, and the honorary consul, Canadian honorary consul to Dominican Republic, actually notarized all these and swore the oaths and did video of the whole thing. So later, if it was questioned whether Widlene's biological grandmother actually was there to sign that, there's a video. So when she signed it this time, interestingly enough, and this is actually very important, she did squiggles instead of X's. She still can't write, but she did squiggles. Sister signed her name, Widlene signed her name. It's important to note that she did squiggles. Remember what I said, that if procedural fairness doesn't include all of the reasons for rejection, then you should get an automatic review. Or if the response to procedural fairness by the applicant is completely ignored, that's an automatic judicial review. So let me just skip ahead. We got our rejection letter. It came a couple months ago, and in it, interestingly enough, they say the document was prepared in English by a Haitian notary, signed in Dominican Republic. This is highly unusual that a third language that is not understood by the grandmother will be used. In fact, the most recent document they have was signed in DR and notarized by a Canadian notary, Canadian government notary, actually. So they didn't acknowledge our response to procedural fairness. Should be an automatic judicial review. And in case that's not convincing enough, the next point, document acknowledging the translation is signed by your grandmother show a mark of 3 crosses, whereas normal procedure for someone who cannot sign is to use a thumbprint. No crosses, no X's. She used squiggles on this one, so they have ignored the new document. That, according to Canadian law, is an automatic judicial review. Now, if that wasn't enough for the automatic review, secondly, if they haven't given you all of the potential reasons to reject in your procedural fairness, then they haven't given you the opportunity to address them. So if there's new reasons, the 13.5 pages that they gave us of reasons for rejection, These 3 took up about a paragraph. The other 13 and a half were completely out of left field, new reasons, including the presence of a biological father who's a mythological figure. He's a fictional character, he doesn't exist. The living situation once Widlene is in Canada, the role that the province of Ontario played. All these were sprung in a rejection letter. Well, not the rejection letter, the long form rejection letter that we had to get a court order for. So they hid those in a rejection letter that they didn't actually voluntarily give us. And that's an automatic review as well. So as you can see, this system is rigged so that the applicant never gets a fair shake at procedural fairness. We never got procedural fairness. And that's just one of the many problems along the way. So that's where that's the concept of procedural fairness. The next video I'm going to do will be on the role of the province and what the inconsistencies were in that. And that one's going to be very interesting because both jurisdictions are saying the other one did something, and we've got written proof that shows neither did. So check that one out. That's the next video coming.